Your Honor, I'm Mr. Abir, appearing on behalf of the prosecution. This is an application to adduce a bad character evidence of the defendant under Section 101 of Criminal Justice Act 2003. Your Honor, may I check if you have all the relevant documents in front of you? The list have been provided in paragraph 2 of my skeleton argument.
I've checked, and yes, I do have the list that you provided from 2.1 to 2.11.
Sir, did you have a chance to go through them?
I've looked at them, yes.
Will a brief summary be helpful to assist the court?
No, I know the facts of the case.
Your Honor, all the relevant laws and the statutes and case laws has been provided in paragraph 7 and paragraph 8 of my skeleton argument. Your Honor, I have broken down my submission into two different parts. Firstly, Your Honor, I would like to seek leave from the court to adduce the defendant's bad character under Section 101(1)(g) of Criminal Justice Act 2003. Your Honor, if I may take you to paragraph 7.3 of my skeleton argument.
Yes.
101(1)(g) of Criminal Justice Act 2003 states that defendant's bad character is admissible if the defendant has made an attack on another person's character, which in our case, Your Honor, defendant has made an attack on the injured party's character. Your Honor, if I may take you to the police interview record, which is exhibit IMC1, which was taken on 22 December 2015.
Yeah.
Your Honor, throughout the interview, you can see that the defendant gave no reply answers, apart from the last question when he was asked whether he has anything else to say. That is when, Your Honor, the defendant attacked the injured person's character. Quoting, reading it out from the paper. Look, I'm saying that little prick would say anything. He was always as high as a kite, always smoking weed and stuff, can't believe anything he said, and he is a dork. Your Honor, it indicates that he is not only denying that he was there or he has committed the offense, but he's saying the quote that he was not there at all, and instead he's indicating that the injured party is a liar, is fabricating evidence, he is not he's not worthy of belief at all, and he takes drugs. Whereas, Your Honor, the injured party is completely clean and has no previous records. Therefore, Your Honor, considering the matters, the court should allow leave to adduce evidence of the defendant's bad character under Gateway 101(g) of Criminal Justice Act 2003, as this will help the jury, Your Honor, to get a clear picture of the defendant's character and to reach a clear verdict. And it should be permission should be given to adduce the character regardless of how old they are, Your Honor. If I may take you to paragraph 8.3 of my skeleton argument.
Yeah.
This is a Court of Appeal case of R versus Clark, where it was held that regardless of how old the convictions are, they should still be admissible to give the jury a full detail of the person making accusations against the victim. Therefore, Your Honor, as the defendant has launched an attack on the injured party over here, therefore, evidence should be admitted to undermine the credibility of the defendant, and it will not have any adverse effect on the fairness of the proceedings. In fact, it will assist the jury to print a clear picture of the defendant's character and assist the jury to consider the charges, reach a verdict and consider the charges of ABH and theft. Alternatively, Your Honor, if you're not convinced, I would like to seek leave to adduce defendant's bad character evidence under Section 101(d) of Criminal Justice Act 2003.
Okay.
Your Honor, in this scenario, the defendant's bad character is relevant to important matter between the defendant and the prosecution due to number of previous convictions, previous offenses which he has committed. And it does show a clear propensity that he has a clear propensity of committing such offenses he has been charged with. Your Honor, if I may take you to the history of defendant's previous convictions.
Yes.
Your Honor, you can see he has number of previous convictions. First of all, 2 of them were for battery. One on 11th of December 2009, trying to steal injuring his teacher, and another one on 11th of April 2012, injuring his bus driver. In both occasions, the injured victims had suffered cuts on their faces. And another offence, Your Honour, you can see as 2 previous offences of ABH. One on 11th April 2014, where he kicked a pupil and punched outside the school building. And another one, which is on the last page of the previous conviction list, assaulting a constable being drunk on the street when he was asked to stop shouting while he was shouting obscene language. All these are relevant to count 1 of the offence of ABH that he has been charged with. As similarly in this case, he has unprovokedly attacked the injured party in a park. The defendant also has a number of previous offences for shoplifting. First, on 17th of June 2013, where he tried to steal alcohol. Another one on 18th of June 2014, where he stole jeans from Primark. It was immediately a year later, and again on 16 March 2015, trying to steal alcohol again for the second time. The defendant has previous offences for theft as well, Your Honour. First, on 22 of December 2014, stealing designer clothes from a store, and on 10th of August 2015, stealing a purse from an elderly lady. All these convictions are, Your Honour, relevant to count 2 of theft, which the defendant has been charged with, which clearly shows that he has propensity to steal, and he has a propensity to steal alcohol, which he has done in this case after injuring the person, and then he took away a pack of 12 cans of alcohol. However, Your Honour, there is a little gap between the first 2 convictions of battery. However, it is just a little gap of 3 years. If I may take you to paragraph 8.2 of my skeleton argument, the case of R versus Cohen, where again the Court of Appeal held that all conviction with a long gap can still be admissible where it shows the propensity of committing such an offence. Therefore, Your Honour, making this conviction admissible will not cause injustice, as the previous convictions show that he has propensity of committing these offences. Therefore, considering the points, Your Honour, the court should grant a leave to adduce the bad character of the defendant in the interest of justice, as without it will be difficult for the jury to paint a clear picture of the defendant and reach an accurate verdict. And, Your Honour, it will not be unjust, or it will not affect the fairness of the proceedings at all, unless and until I could be a further assistant.
Well, I'm curious with regards to the battery of 2009 and 2012. The defendant was less than the age of 16 in those 2 offences. Whilst those offences themselves aren't significantly a long period of time ago, given his age, is it not unfair to adduce those particular bad character points, particularly in light of what Hansen says, and the fact that you have a remaining ABH from 2014 and assault PC that you can still look to rely on?
Your Honour, I am relying on the ABH and other charges. In terms of the battery, the defendant is 19 years old at the moment. Therefore, Section 108 of Criminal Justice Act 2003 does not apply, as it applies for only individuals who has been charged at 21 and over. And in terms of the case of R versus Hansen, Your Honour, R versus Hansen sets out 3 principles. Therefore, applying the principles of R versus Hansen, the defendant Your Honour, if I may take you to the transcript of R versus Hansen, which is in page 1 of the case bundle.
Yes.
Over there, Your Honour, you can see there, although the facts are not exactly relevant to our case, but it sets out 3 principles. Firstly, does history of conviction establish a propensity to commit an offence of the kind charged with? In our case, it clearly does, Your Honor. He has previous convictions of assaults and theft.
Okay, that's it. Stop there.